Chapter 20, we get going here talking about employment discrimination. I find this, of course, I think having been in private industry for so long, I find this really interesting and compelling, and it's just an interesting topic, I guess, in my opinion. So let's run through it. We'll talk a lot about Title VII. Make sure that you know that the perhaps the most important legislation dealing with employment discrimination was Title VII of the Civil Rights Act of 1964. Now, the Civil Rights Act of 1964 covered many other things besides employment discrimination, other types of discrimination, of course, but Title VII dealt specifically with employment discrimination, and so many of the things we see in today's law really originated and stemmed from the Title VII of the Civil Rights Act of 64. Prior to that, there were civil rights acts, right? 1866, right after the Civil War, right? Some executive orders, my guess, 41 and 43, those probably had a lot to do with the war going on and probably opening up some employment opportunities because of the need for labor and whatnot. Equal Pay Act came before the Civil Rights Act. Age discrimination in employment and Equal Employment Opportunity Act in 72, and then the ADA in 1990. All of those extremely important acts, and of course this one, Civil Rights Act of 64, being the biggest. Suits filed by the EEOC, and that's the total number. That's not in thousands or millions or anything like that. That's the total number. It doesn't look like that many, right? What's important to note is that, generally speaking, these things get negotiated. Okay, if a employee files a lawsuit files a claim, completely different than a lawsuit, in order to exhaust the procedures that they have to go through, they'd file a claim, and that would go to the EEOC. Normally, the EEOC and the employer are going to work something out, okay? Or oftentimes the EEOC might not find any reason to believe that there was discrimination, and then would write that letter to the employee and say, we're sorry, we've reviewed your claim, but we don't feel it has merit. They call it a right to sue letter because usually the last sentence is that, that doesn't mean that you can't sue them in a court of law. You can't pursue your interests in court. I guess I should do it like this. Sorry. Make it a little bit bigger for you guys. And the types of suits, of course, primarily are under Title VII. ADA maybe next, ADEA, APA. I don't know how employment and EPA suits, of course, is 000, and then you get here a little bulge. I don't know why in 2001, 2002. Okay. Title VII of the Civil Rights Act 64 prohibits what kind of conduct. Let's go with C, discrimination in employment. That's not to say these others are not prohibited, but this one, Title VII of the Civil Rights Act, dealt with discrimination in employment. Kind of a lengthy little comic. You guys can look through that. So who does it apply to? Well, employers with 15 plus employees. That doesn't mean, by the way, that other employers can discriminate, right? Just means that their cases may be handled in other facets of law. Local laws, local rules, those types of things, right? State laws, perhaps. The purpose was to eliminate job description. These were the 5 original protected classes. Okay, know these for sure. They should be on the test. Race, color, religion, sex or gender, and national origin. Those were the 5 original protected classes. There have been a number of them added to that since then. Age, for example, marital status, for example, military service, for example, familial status, and more recently, rights dealing with gender identity and sexual orientation. It does make exceptions basically for bona fide occupational qualifications, and we'll talk about some of those, but we'll talk about those right now, I guess, since that photo came up, right? Okay, and I put that in there and not be, what do I want to call that? I don't want to be getting out there a little bit. I just wanted to point out that, or ask the question, is that a bona fide occupational qualification? This guy is obviously celebrating maybe his birthday or something at Hooters, I don't know. And for those of you that have been to Hooters, you know that the waitresses, the wait staff that works there, tend to, not just tend to, they definitely have an appearance, and there is an appearance requirement, okay? And they were sued over that, Hooters was. As the suit progressed, it ultimately settled, okay? And Hooters, I think, was on the verge of successfully showing that this was necessary. This was a necessary part of their business plan, okay? And if it was a necessary part of their business plan, then, they'd probably be allowed to continue on, right? So it ended up settling. In the agreement, Hooters agreed to, maybe hire more guys and other folks that might work behind the bar, in the back rooms, those types of things. But the wait staff would continue to have certain appearance requirements, okay? And what I'm going to tell you, and we look at that as an example, is that these areas are extremely gray, okay, extremely gray, as to what fits and what doesn't, and they're left on a case-by-case basis to be settled in the courts if need be, okay? Gets to be kind of expensive and whatnot, but okay, types prohibited, of course, discharge. We can't fire people based on their race, color, religion, sex, national origin, or any of the newer ones. Can't refuse to hire. Can't compensate differently. Okay, nor can we provide other terms, conditions, or privileges that we would do in a different fashion for one people of one race, say, versus people of another race or color or religion, etc. Enforcement of Title VII of the Civil Rights Act goes to the Equal Employment Opportunity Commission, again, the EEOC. Remedies can include back pay, injunction, right? They can force you to be reinstated, with back pay. Tell you that, certainly they can't retaliate against you, those types of things. And there can be other compensatory damages. If you, what would that be? Well, if because you lost your job, maybe your car got repossessed or something. Okay, they might have to fill in and make up for some of those losses that you incurred too, and there can be punitive damages. I think those maybe tend to be a little bit rare. Charges have to be filed within 180 days, and this changed a little bit. The Lilly Ledbetter ruling, I believe, is what it was, because this says that charges originally said charges needed to be filed within 180 days of the incident. Okay, and Lilly Ledbetter had worked at a place, and I think if I remember the case right, there was kind of an ongoing, whether it was harassment or something that was going on. And while the last incident may have taken place in May or whatever, she didn't quit working until the next January, and then she filed her lawsuit in April. Okay. And originally it was thrown out and said that because, the last incident was almost a year earlier, something like that, they wouldn't proceed. But the courts held no, that maybe that was a miscarriage of justice, and that 180 days could apply to her, in her case, that last day of work. And again, I think it creates a case-by-case analysis of those things. So what are the claims, right? Unfair dismissal or wrongful discharge. Okay, breach of contract, okay, wages, race discrimination, those types of things, okay, kind of a breakdown. Again, there's not a ton of them that are enjoined by the EEOC. That's not to say that there's not a lot of court cases otherwise. So what's the difference here? Okay, there's disparate treatment. That's when an employer intentionally discriminates, intentionally hires a man over a woman, even though the woman may have been more qualified. okay, um, without other, bona fide occupational qualifications being inherent in the job, right? Inherently hires one race or religion over another, okay? Again, those bona fide occupational qualifications not being necessary to the job, say. So this is overt, right? This is an overt kind of a mono-on-mono thing, right? Disparate impact is there's a discriminatory effect, and not necessarily through overt actions, maybe more negligence of the employer. And the best example I can give you is Walmart settled a case here 5 or 6 years ago, and why they couldn't figure this out, I don't know, but somebody on the outside had sufficient information to show that women in Walmart in the same jobs were being paid on average, I think it was 3 or 4% less than guys. Kind of a strange phenomenon. And, there wasn't any order from Walmart in Bentonville, Arkansas, to say that that's what they intended to do. And there wasn't any order at the district level or the regional level or anything like that. It just appeared to be an oversight. Okay, this general oversight, or this general, just kind of this management policy, not policy, because it certainly wasn't in their policy, but management procedures that allowed for this to happen. When this got settled, I remember I even had one gal in my law class at that time who worked at Walmart. She got a check for 170 some bucks or something like that. That was back pay, okay, for what she had potentially had not been paid and should have been paid while she'd been working at Walmart. So again, there wasn't any real intentionality about it. It's just kind of one of those things that I guess you could say it slipped through the cracks, but shame on Walmart. Like I said, why could somebody from outside the company figure that out and enough so that they could file a lawsuit when the people inside the company weren't keeping track of those things? So, and then retaliation is adverse actions against an employee maybe that files a claim, right? So if you file a claim, okay, the company's not allowed to retaliate against you for the filing of that claim. Now, there have been a number of cases where, maybe a person files a claim and they subsequently get fired, but they were fired for a completely different reason. And the courts have said, as long as that other reason is legitimate, we can't stop the business from conducting business the way they normally would. Okay, so again, a lot of gray, a lot of court actions can take place as a result of these things. So, okay, kind of talked about those. Then we get to the other one, which is harassment. And I'll tell you the story about that in a second here. But so harassment, oftentimes, sexual harassment probably gets termed as, but harassment's harassment, I guess. And what it can be is one, quid pro quo, or two, hostile work environment, are the two ways they divide that. Sorry. Forgot to unplug my phone before I got started. Okay. A defense for all of these can be that it's a business necessity. That kind of gets back to the defense of Hooters, right? That their employment practices were a business necessity. Okay, I think we'll talk about quid pro quo and hostile work environment in a little bit, so I'll wait on that. But the story behind this doesn't really have anything to do with employment law, but it's kind of a cute story, sort of. The guy that owned this house, he built it, and there were regulations that limited the height of the house, okay, the maximum height of the house apparently. And he exceeded that by 18 inches. And so he went then to try to get a variance. He, screwed up, admitted it or whatever, but he went to try to get a variance, and one of the neighbors refused and said, no, I'm not going to allow that to happen. You need to take your whole roof off and lower it by the 18 inches. And the guy had to comply with the law, so he took his roof down 18 inches, and when he put it back up and put his house back up, I don't know if those are shutters or what, or vents, or but that's what he put. And of course, the guy filed suit against him again, saying that was inappropriate. And this time, the guy that owns this house, he won, so he got to keep that up. So when the guy wakes up in the morning, that's what he sees. maybe I don't have. So, quid pro quo means something for something. So, that again is kind of an overt action. It's, I will give you this promotion if you go out with me. It's kind of the nice politically correct way of saying those things, right? I'll give you a raise if you provide me certain favors, those types of things, right? Hostile, and that's fairly straightforward, those types of things. Okay, hostile work environment's a little different, and again, it's a real gray area, and the courts have purposely said that they want it to be gray because, what we perceive as a hostile work environment in Montana, for example, might not be the same as a hostile work environment in Boston, right? Or in maybe different parts of Boston, even, right? And so the courts interpret it different, and each case stands on its own merits, kind of depending on where the action takes place, where the employer is, it's, how other employees are treated and react, and those types of things. So, pretty gray. Yeah, I'm sorry I can't give you black and whites on a lot of these. So, to avoid retaliation claims, and I think this is important in any case. Okay. That number one, you have to treat complaints seriously. Probably, if you read a lot of these cases, you find that that's oftentimes the biggest problem that happens is somebody files a complaint, and it kind of gets swept under the rug maybe a little bit. Okay, not the best idea, right? Okay, we need to investigate these claims, follow, make sure that we're following our policies and the laws, of course, follow up. Okay. We also have to make sure that we're providing a comfortable atmosphere for those who might complain to come forward, right? And we can't have adverse actions against those who do come forward. Not at least we can't have adverse actions for that reason. So, again, discrimination based on race or color, any of the things we've kind of already talked about that, right? And kind of a harassment type might be, right, anything that permits racial insults, okay, or anything if we maintain all white, all black crews, okay. If better housing, maybe higher Christmas bonus, maybe tickets for the ball game, that we give always to the white guys that happen to be in the crew or whatever the case may be. And those things would be, any of those types of things would be prohibited. And again, some of those might be a disparate impact thing, and some of them might be a disparate treatment thing, depending on if it's overt or not. There might be tickets for the ball game that just constantly get given out, and maybe the ones that ask the most often happen to be white guys, and so they seem to get all the tickets, and maybe there wasn't any outreach and should have been to encourage others to step forward and get the tickets. Okay. Some disparate impact examples can be biased personnel tests. There's been a decent amount of law, different companies do personnel tests, and it's an important thing that they be non-biased, and a lot of companies use third-party testers for that reason. So there was a big case up back east, I think it was in Boston or someplace in Massachusetts anyhow, and a city had their fire department, they had a testing that allowed folks to advance from being a firefighter to being a manager, officer, whatever they call them in the fire department, I'm not sure. And they ended up taking the test, and in the end, in this particular year, in this one test, only white guys passed. And there had been, I don't know if it was an equal number, but a significant number of both white guys and minorities that took the test, but only the white guys passed. And the mayor stepped in and said, well, wait a minute, we can't have that, so we're going to promote some minorities, maybe as an equal representation, regardless of the test results. And of course, those white guys that had passed the test and didn't get promoted sued. Right? They said that's reverse discrimination, and they won, and it all hinged on this. They had a third-party test company that had prepared the test and administered the test, and they proved beyond a reasonable doubt, I guess, or at least there was a preponderance of evidence that, they proved that their test was unbiased. Okay, they proved that their test was unbiased, and so in this case, the white guys won, the lawsuit, and they were promoted, as as the test results had indicated. Denying employment to unwed mothers. We don't hear too much about that so much anymore. Poor credit rating, but this can be used. Credit ratings can be used sometimes in employment situations if it's pertinent to that particular employment situation. And a priority to present employees, you can have some priority. There are reasons that you can't have priority to present employees, but in some cases you cannot. Okay, just it might depend on how your business is set up. Other discrimination, right? National origin or language. Language can be a bona fide occupational qualification, though, right? Absolutely, it can be a bona fide occupational qualification. If you need to speak English, that's fine. If you need to speak Spanish, okay, because the clientele Spanish, that can be a requirement. Okay, so that can absolutely be a bona fide occupational requirement. Religion, reasonable accommodation. So this gets to be interesting. If you're Walmart and you're open on Sundays every Sunday, and somebody wants to come to work for you that wants Sundays off because they go to church, is that a reasonable accommodation? It might be. In today's day and age, that might be an accommodation you might be required to make, and the reason would be is that there's plenty of other people that don't require Sunday off, right? That to them Sunday or Monday might not make a difference, and so it might be a reasonable accommodation, okay? Or if you're Seventh-day Adventist, it might be Saturday off, okay? Or whatever day it happens to be. And certain religious holidays, we're accustomed to the Judeo-Christian holidays that we celebrate here in the U.S., but there's other religious holidays that other religions might celebrate, and they might need to make accommodations for those. So again, sexual harassment, we kind of talked about hostile work environment. What's a hostile work environment? Again, it varies. In the mechanic's garage, in downtown Havre, if they, hang up the Playboy calendar or the Maxim calendar on the wall because, that's what they prefer on their bathroom wall or something, that might be fine. That may not be okay in São Paulo or San Francisco, or I was trying to think what's the Palo Alto or any of those places, right? Might not be appropriate in those places, and so it's case by case. Pregnancy Discrimination Act. This one's relatively new. I think that one is the one was 90 or 91 maybe. Interesting. Before then, employers could legitimately discriminate against pregnant women. Gal might get pregnant and say, "Hey, I need some time off to have a baby," and la da da, and the boss could say, "Oh, I might not have a job for you when you get back." Again, that's hard to believe. That one was not that long ago that passed. Okay. Now, of course, we have the Family Medical Leave Act, which allows them up to 75 days, but it depends on the size of the company there too. You have to have 75 employees or more. Okay. Equal Pay Act says that folks working the same job, roughly the same qualifications, etc., should be paid the same. Sexual orientation, the reason I have a question mark behind there, and I'll have to remove that here probably, but this is still very new. Okay, this is new law. Just in the last couple of years, Montana, 8 years ago or so, a referendum that was proposed and it passed by two-thirds to one-third in the state of Montana that said marriage was between a man and a woman, period. And it was the public vote. It was democracy, the public vote. But court cases now and subsequent rulings and whatnot have said that maybe not, right? And so sexual orientation, I would now say, is a new protected class. 3 years ago, probably I wouldn't have said that. I mean, the law has been that new and has changed that much. Gender identification is probably the newest one, right? That's in the process, I would say, of changing, and we'll see.
Bye.
And testing educational requirements can create a disparate impact. And so, can you have educational requirements? Yeah, to a certain extent. If your employment requires at least a modest educational attainment, that's fine. Can you require a bachelor's degree maybe for somebody that's going to be a checkout person at Walmart? Probably not. It's probably not necessary, right, that they have that level of educational attainment. Okay, probably wouldn't apply. Many of them would apply, but they might. Could you require a high school degree or a high school diploma? Yeah, maybe. High school GED equivalent? Yeah, maybe. That'd be a call shot there. At Walmart, especially where things are so automated anymore. Okay. You could require that they pass a test of your making. Maybe some basic things with some math and whatnot. Weight and height requirements. Probably not unless. There could be certain circumstances where weight and height could be appropriate. There's a bad example maybe, but back in World War II, I don't know if you guys, I've had the opportunity to be on a couple of World War II submarines. They required that people be short that were on the submarines, and if you walk through one of those, you'll understand why. If you were 6'6", you wouldn't have got along real well. Okay, and so there could be some cases, right, where weight and height requirements could be appropriate, but they're pretty limited, right? Appearance is a business necessity. Okay, and that could be legitimate. If the local McDonald's wants you to not have a bunch of tattoos and earrings and nose rings and those types of things, they may be able to put some policies in effect to do that because it may be considered a business necessity. There's old folks like me that don't necessarily want to go and purchase my food from somebody with a lot of metal hanging from all parts of their body, et cetera, right? So those things could be, okay, again, it's case by case. Sorry I can't give you any black and whites on these things. Affirmative action, and I think we talk a little bit more about affirmative action in a little bit. Seniority systems are always considered fair. Okay, it's okay to have seniority systems where you promote people based on the amount of time that they have in your place. So, we banned racial discrimination way back in 1866. It didn't have the weight, but I think as you guys saw, and I think that might have been in your assignment, right, that there are some reasons that you could sue under that. That you could skip the procedural requirements, for example, of the EOC, and I think the damages are maybe unlimited as opposed to triple damages like they might have in the more modern one. I think that's right. Age Discrimination and Employment Act protects people that are 40 years old or older, except those that work for the state. Stinks for those of us that work for the state. ADA, we'll talk a little bit about that, but a couple of things that are important here. A pre-employment medical exam. Now, you can require. It's fine if you've got a bona fide occupational requirement. You can require certain medical exams. If for example you're kind of a labor-intensive type of employment and you're worried about somebody's heart and those types of things, yeah. Okay. What's important here is that you make the hiring decision before you ask them to take the test. And so their employment is conditional upon the test, and you'll see that in athletics sometimes, in pro sports. One team will, maybe they're accepting a trade, but the person has to pass a test, right? Conditional upon passing a physical, and that can be the same thing. Okay, reasonable accommodations that do not cause an undue burden. Again, we'll talk about the ADA here in a little bit, and we'll also talk about the Health Insurance and Accountability Act. States have also anti-discrimination laws, and some cities have anti-discrimination laws as well. I don't know in Montana. Missoula might. Missoula's passed a few different laws, I should say, not necessarily strange, but strange to Montana laws recently. In the USERRA, Uniform Service Employment Reemployment Rights Act. Hopefully I got that correct, but it basically provides protection for those people that are, I think, either like in the National Guards who may be deployed and or veterans, who are returning then and still, have rights in terms of employment and whatnot. So affirmative action was an executive order. It's not a federal statute. Now, the goal, and I would say this is probably the goal of civil rights itself, is eventually for it to go away. Okay, I know. Hope you don't accuse me of discrimination or anything there, but the goal would be that there wouldn't be any need for this, right? That people are treated fairly and that we're all treated as one, and that affirmative action just isn't necessary. Okay, and so that's ultimately the goal. And actually, believe it or not, we've gotten a lot closer to that goal than we were 30 or 40 years ago. Administered by the Office of Federal Contractor. Applies to those who contract with the federal government. I know that we were under affirmative action definitely at the bank because we were insured through the FDIC and also Fed, member of the Federal Reserve. So those types of things made us automatically also we're required to have affirmative action programs. Requires that underrepresented classifications of employees must be properly recruited. And affirmatively recruited. So a few issues that have come up. One was quotas. Originally when the affirmative rights came into place, and this would have been in the 70s, it came into place. And one of the first things, a lot of businesses just set quotas in. They said, well, let's see, if in our local area we have 50% Caucasians, maybe 25% African Americans, and 20% Hispanics and 5% Asians and others. That's what we'll have our workforce be. Okay, it'll be 50% Caucasian, 25% on and on. And they sued, and that case was the Bakke case. And the Bakke case ruling came back and said, no, we don't want quotas. We're not telling folks that they have to have a certain number of people on their staff. We're just telling them that they have to affirmatively recruit. The next big case, I think it was University of Michigan, if I'm not mistaken, and they were sued. This was an entrance requirements for the medical school, and a couple guys, I think it was, white guys, got not entered, and they sued. Well, it turned out that University of Michigan had a point system, and the point system allotted an automatic 100 points for people from certain minority groups. And so they sued, these white fellas did, I can't remember what their names were, and they said, it went to the Supreme Court, and the Supreme Court came back and ruled, that point system guaranteeing 100 points like that's almost like a quota system, and we won't go for that. We still want you to affirmatively recruit. We still think affirmative action should be the law of the land, but that's taking it a little bit too far. Okay, and that's kind of where the law stands now. Okay, again, does not mandate or permit quotas. Courts can impose affirmative action, right? If there's a standing history of discrimination. And of course, application of some AA can result in reverse discrimination, and some are, some legitimate, some not. I gave you a few that were. So, ADA in 1990. Having lived through this, I remember being in the business world and thinking this was a horrible thing for businesses to have to comply with. And in retrospect, I'd say nah. That especially some of the what I would think are the big things. They're just common sense things now. I think, if for example you're building or remodeling some kind of a public facility, make it handicapped accessible. I mean, that just seems like a no-brainer, right? And you know why? And maybe we'd have come to that conclusion ourselves anyhow without the law, but ADA just made that the law, right? If you're doing a major retrofit, again, it has to do with reasonable accommodation. If it's not an undue burden, if you're building, just it would take way too much money to make that type of a retrofit. You might not have to, okay? But if you're doing a remodel and you have the ability to accommodate handicap people better, then make the accommodations. Okay, generally speaking, the cost isn't going to be that much more, if any. Okay, and then you can be more accommodative to more people. So that was one of the big things. Okay, no pre-employment medical exam or medical history. Again, that's not to say that in bona fide occupation qualification circumstances you can't require that as a condition of employment, but you do it after the employment decision has been made. So you put people through the paces, resumes, those interviews, those types of things. You make your hiring decision, and then, well, we'll hire you if you pass a physical, say, for example, if it's a reasonable requirement for your job. No discrimination based on, right, disability or past are regarded as having, and the definition of that is if there's a substantial limit to a major life activity, walking, seeing, hearing, use of arms, those types of things, right? Can also be mental. So, process of adjusting job or work environment to fit the needs of the disabled employee. It's not always the employee's choice, right? As long as it's reasonable. So, in most places, work these things out. Okay. Somebody that just has trouble standing for long periods of time, if they're a teller at a bank, is it okay if they have a stool? It might be that simple, right? Do some more complex ones, right, where people might need to sit down on the job, or people might need an little extra break time, or again, there could be some complexities. People might need the job place to fit or accommodate them in a motorized wheelchair, something like that, right? And as long as it's reasonable, not terribly expensive, not an undue burden to the business, they'd be required to do those things. Genetic information. This is a new field, right? 2009, not too long ago, right? And the whole genome has been mapped now, and so some of these tests are coming along, right? And some of these tests might show, for example, that maybe you're susceptible to Alzheimer's or dementia at an early age. Okay, and you're 60 years old and applying for a job. What if your employer has that information? Okay, this came along and said, we're not going to allow that. IBM was one of the first ones. They actually created some of the original tests that had to do with that, or at least the computing power in order to process the test, maybe. And they right away could see how it could be abused and misused, and so they made a company policy. They were first, and like I said, they were the ones to really kind of develop or help develop the testing, and they made it a company policy that they would never discriminate based on a person's genetic information. And I mean, they had people who were volunteering in the company, right, to test some of these things, and so information might come out that geez, you're going to have Alzheimer's when you're 56 years old or something. And so they said, no, we're not going to discriminate. Discrimination in health insurance. The Health Insurance Portability and Accountability Act says, right, we can't exclude people from insurance coverage or requiring different premiums based on, health status, medical condition history, et cetera, et cetera. So if you apply, there again, if you apply for a job and maybe you've got, maybe you're a cancer survivor, and maybe your type of cancer could be one that's recurring, and so it's gonna be expensive for the company if you're on their health insurance, or at least it's gonna maybe increase the health premiums or whatever. They can't discriminate against you based on that. Okay, they can't ask about that even before they hire you, really. It might show up in your physical, but if it doesn't limit your ability to do the job, they can't discriminate just because it might raise the insurance premiums for the whole company. Okay, And that becomes a size thing. If you're General Electric that has a gazillion employees, bringing a few on that have some of these conditions might not be a big deal, right? Because you spread it out over so many people. A little different, if you're a smaller firm with 100 employees. It could create a bit of a hassle. And I don't know how, the Affordable Care Act, if that, I don't think it did, made any improvements in this. Some state anti-discrimination laws, again, often created under state laws. There's certainly states that have been more proactive in sexual orientation and gender identity and those types of things than other states. Okay. State laws can often protect, right, categories of people not protected under federal law. State tort and criminal law penalize those who discriminate, certainly. So what are we seeing? We're seeing a surge in private lawsuits. So go back and again, the procedure, if you feel you're discriminated against, and if you're covered under the EEOC, some folks are covered under the EEOC, which is federal, and more probably, or a bunch anyhow, underneath the state law. Okay. And so if you're covered under the EEOC and you feel you're discriminated against, you file a complaint with them. Okay, they'll acknowledge your complaint. They'll forward that complaint to the employer, which time the employer has to respond. Okay, and they can't retaliate against you in the meantime. And generally speaking, or oftentimes, something just gets worked out then. Okay, depending on the nature of the complaint and whatnot. If the complaint's bad enough, and if the company refuses to back down, maybe the company says, no, we feel that we're right in our decision here, the EEOC might take up the case, meaning that they would serve basically or hire the lawyers then that would sue the employer. Okay, that doesn't happen all that often. Generally, again, if it gets to that point, the employer and the EEOC/employee figure something out. They come to some sort of an accommodation. Okay, but if it gets to that point, the EEOC will act basically as the attorney and represent the person. And a lot of times then the EEOC says that, I'm sorry, we don't find any basis for a claim here, and but you have a right to sue, and that's where you see this surge in private lawsuits. Okay, so you see folks then almost taking that as an obligation to sue as opposed to a right to sue, even though the EEOC didn't find any basis for a claim. In the state of Montana, we have a similar thing. We have Human Rights Commission, which acts like the EEOC for state ones. So if there's a state claim, okay, and I don't know what the division of employers and employees is. I would guess that if you're federal contract, those types of things, you're probably covered under federal law. I really don't know what the division is there, but otherwise you're covered under the state law. But the human rights, again, it would be very, very similar. I know we dealt with one. We had a discrimination in back in the banking for a lending issue, and it went to the Human Rights Commission here at the state level. So even though we were federally covered, so I thought that was kind of interesting. Again, the brand new discrimination based on that. Arbitration in discrimination disputes. I don't know if you guys saw, but Wells Fargo is pushing for arbitration with their employees in the disputes that they had over the sales tactics and whatnot. And then insurance against discrimination claims. I can tell you a story about that too with my buddy, but that would be a long time, and I've already gone on long enough for this one. So I will sign off and see you guys next week for our last week.